Hello there, good afternoon, and welcome to this special discussion. The Court of Appeal today ruled 2 to 1 that petition number 99, elections petition number 99, that the court has jurisdiction to hear that petition. As you would recall, earlier this year, the Chief Justice would have dismissed that petition for failure to serve or failure of service. I have with me, responding and reacting to the ruling today, the Honorable Attorney General and the Minister of Legal Affairs, Anil Nandlall. Minister, good afternoon and welcome to the program. Your response immediately to the ruling today.
Thank you very much, Eddie, for inviting me to be part of this discussion. And the government's reaction is one of disappointment. We feel that the learned judges of the Court of Appeal erred, the two of them, and we are convinced that the Guyana Court of Appeal has no jurisdiction to hear or determine the appeal that is before it. As you correctly asserted in your introductory remarks, the decision of the learned Chief Justice struck out and or dismissed the petition on the ground that it was not served within the time prescribed by the particular rules and regulations and principles of law governing election petition in our country. Our position, as I have stated over and over again, is not unique. Our position is in consonance with the English-speaking Caribbean and indeed the English-speaking Commonwealth. And Guyana, therefore, doesn't stand in isolation in relation to these rules and regulations. And the decisions of courts across the Caribbean, in Guyana, and across the English Commonwealth have been consistent in election jurisprudence for nearly 500 years. And there is hardly any inconsistencies. In fact, it is one area of the law that one can argue very confidently and very emphatically that the jurisprudence is uniform, the court decisions are consistent, and the positions in relation to law and in relation to procedures are quite clear, and indeed the jurisprudence requires such, simply because you're dealing with the election of members to a National Assembly or a Parliament, and you're dealing with the constitution of a government. And therefore, the law and the jurisprudence and the policy that informs the law and the jurisprudence is such that disputes arising out of an electoral process must be resolved expeditiously and with every convenient dispatch, because a country, a nation would be in chaos and confusion unless the government is settled and the members of parliament's elections is settled. Hence the rationale for there to be clarity in the law, and there is clarity in the law. But with rulings like this, that clarity now becomes murky and it becomes discolored, and this is very worrying in our jurisprudence.
I want to ask, Minister, because I think when you look at the composition of the Court of Appeal, the three judges, aren't these the same judges that rule here would have ruled in 2020 during the elections, the issues that we had then, ruled that the court had jurisdiction in another matter where I think it had no jurisdiction, and the court or the CCJ, I think, would have made some comments with regards to the ruling of the court then. If you can take us back there before we move forward.
Well, it even goes further than that, Eddie, because viewers would recall the challenge that was made against the no confidence motion passed in the National Assembly in December 2018 that predated the elections. The Chief Justice had ruled that the no confidence motion was properly passed and was valid. That decision of the Chief Justice was appealed. And two judges, Justice Barnes and the Honorable Chancellor of the Judiciary, had ruled then that the no confidence motion was not properly passed, and had made that what became an almost infamous pronouncement that 33 is not a majority of 65. That is the same quorum, or those are the same two judges who have ruled in this way today, and that is public knowledge. There were another two judges also who ruled in that particular way that you are referring to. But what the point that must be made, and an objective bystander would recognize, that during the lead up to the declaration of the final results, that is, between the March 2nd elections and the ensuing 5 months, you would recall that there were a series of litigation. The world and Guyana were watching. A lot of people became acquainted with principles of law that they never heard of before. Ordinary members of the public who were viewing with great interest. Many things became clear in that process. If one were to examine the rulings that emanated from the court and remove from them their esoteric content and complex legal principles, and one were to draw from those cases and court pronouncements certain principles, among those principles, one would have concluded was that an election law and elections jurisprudence were unique, and that the principles that emanated or that related to election laws and the holding of elections were peculiar, and the court's jurisdiction to hear and determine those legal challenges were special. Those were the words that were used. That much, I think, is clear to the ordinary Guyanese and the ordinary onlooker. And that is what is shocking about this court's ruling today, because the court, the two judges who ruled in the way that they did, resorted to ordinary principles of law, and they eked out a jurisdiction that, in my humble and respectful view, election jurisprudence says does not exist. It is settled law across the English-speaking world that an election petition is governed by certain special laws and certain provisions of the Constitution. And it is only the combination of the two that inform how these cases in relation to elections petition are to be heard and determined, and the procedure to be employed in relation to these cases. In particular, which court must hear them, and if an appeal lies, where the appeal lies to. And if an appeal doesn't say, if the law or the Constitution doesn't say that there is an appeal, then there is none. And one can't, by implication, find a jurisdiction, or one can't resort to the ordinary jurisdiction of the court to find a right of appeal. One is confined to the four corners of the electoral statutes and or the relevant constitutional provisions. And these two judges, in my respectful view, violated those fundamental tenets and canons and gave the Court of Appeal a jurisdiction when the election laws and the election constitutional provisions did not give the court a jurisdiction. And that, I believe, is quite unfortunate. There is another point that I want to make as well, and it is this. Now, it is not the first time that a case, an elections petition, has been dismissed for want of compliance with some procedural rule or some procedural requirement. And dating back centuries, you would not find one decision that has been appealed. It is improbable, if not impossible, to think that all those lawyers and all those litigants against whom those types of decisions have been made were not aggrieved by those decisions and therefore did not want to appeal them. There must be a reason why those decisions were not appealed. And the reason why is because they were simply not appealable. And those points were made very, very clear and emphatic to this honorable court. In particular, in relation to Guyanese cases, where a number of election petitions filed in Guyana since independence were struck out based upon preliminary grounds. In fact, if one is to go back to the challenge to the 1968 elections, that petition was dismissed on a technical procedural ground. The 1973 elections was challenged by an elections petition. That also was dismissed on a procedural preliminary ground. Then the 1985 elections were challenged by another elections petition. That was dismissed on the ground of, among other things, non-service. Then the 92 elections was not challenged. The 96 elections was challenged, but that was Horner determined. That is Esther Pereira. The 2001 elections, I think that one was not dismissed on procedural ground. I don't think so. But in 2006, there was a petition filed against those elections in relation to the Linden seat, filed by a gentleman by the name of Melville. That petition was also dismissed on procedural ground. None of those cases were appealed to the Court of Appeal on those grounds. Why? Because it is not appealable. But here you have all the clarity that exists in the law, in my respectful view, now becoming unclear with these rulings, or with this ruling. And certainly, the government will appeal this decision.
So, I know you touched briefly, Minister, on, because I was to ask you the next step on the fact that you've mentioned now that indeed the government intends to appeal the decision, and you've touched briefly on some aspects of the ruling, and I think you've outlined really what happened. But I want to take you back to, you keep mentioning that the laws that govern elections petition are a specific set of laws, if you want, and outlines the jurisdiction of the court and which court and so forth. Maybe if you can, for the benefit of the public, because I know this question we've heard repeatedly during the 5 months of the election troubles, if you want, or struggles that we had in 2020, of how you can appeal a decision and well, how you can challenge a decision and which court has the jurisdiction. If you can point out for us which part in the law, in the Constitution, speaks specifically to this and what it says.
Article 163 tells you that anyone who wishes to challenge an election must do so in accordance with the provisions of that article and upon the grounds stated in that article. And the article continues to say that once, if those grounds are determined by a court, and anyone, or those questions rather, that's the word I use, if those questions that the article says the elections can be challenged on, if those questions are determined by a court and anyone is aggrieved by that determination, then an appeal lies to the Court of Appeal. The questions that were posed in this election petition number 99 were never determined, simply because it did not even get off the ground. They did not serve it upon the proper parties within the time required. And the election law says that if there is non-service, it is fatal that the court has no jurisdiction to hear and determine a petition that is not properly served. So the door was not even opened for the court to address the questions that the petition posed. And therefore, if the questions were not addressed, then how the law says very clearly that only if those questions were addressed and there is a determination of those questions, then an appeal lies. And all the other law says that this is a unique jurisprudence, it's a unique process, that this is something that the court inherited from Parliament. It's not part of the court ordinary jurisdiction. It's not part of the court's regular jurisdiction. The court is not sitting in its civil jurisdiction or in its criminal jurisdiction as it would do to hear and determine a civil case or a criminal case. This is a special jurisdiction carved out from the Parliament, because these disputes used to have been settled by the Parliament. And the Parliament carved it out and said, look, High Court, take this special jurisdiction. I am giving you some special rules that I want you to use when you're exercising this jurisdiction, when you're settling these specified types of disputes. Follow them. Don't depart from them. And these rules are mandatory. Non-compliance will be fatal. That is what was carved out and given to the High Court. That is why the High Court, when it is sitting to hear an elections petition, it is called an elections court. It is a special court. It's not the High Court that we know as the ordinary regular High Court. And all of that today apparently was not observed. And we have the ruling that we now have.
And AG, it brings me to, and I may wrap with this. Not so long ago, we saw a number of professors from the University of the West Indies, including one person who came here at one point to supervise on behalf of a CARICOM, the elections recount process, speaking specifically about some of the actions taken by the appeals court during those matters that were brought during the elections issues in 2020.
Well, the persons who were here and were part of the observation team coming from CARICOM, they would have witnessed firsthand what transpired, and they would have observed in awe, and I suppose in horror some of the proceedings that were filed, and would have been equally horrified and equally amazed by the decisions that came from some of our courts. And the persons at that forum to which you have made reference were remarking about their experiences, and in so doing, they leveled some scathing criticisms against the judiciary. Now, Eddie, I want to make a couple of things very clear here. A judiciary is funded by public monies, and it is accountable to the public that it serves. The judiciary is a special institution, and the judiciary has a special role to play. However, the judiciary is not immune from criticism. The judiciary is to suffer the scrutiny of the ordinary man and the criticism, sometimes outspoken criticism, of the ordinary man. However, one can't attribute an improper or an illicit motive to the judiciary for a particular decision, but one is free to make critical comments and to comment objectively on whether a decision of the court is a right one. Of course, there is a process that is out there that allows for that decision to be questioned, but members of the public are free to express views that are critical of judicial decisions and don't necessarily feel that they are going to be hauled before the courts for contempt. Of course, they can't scandalize the court. They can't be disrespectful to the judges. They must be fair, but they can be strong and they can be robust in their criticisms once it is constructive and based upon principles. And I suppose that this ruling, as most political rulings from our courts, are going to be the subject of critical remarks in the public domain. This one is no different.
AG, your closing comments. I mean, all that happened today, all that, which clearly seems to be a case where the appeals court is creating its own jurisdiction, if you want. You may be able to put it in better legal terms, but what happened today? Your closing comments.
Well, what is the next step is that the government will appeal the decision. We have asked the court to stay its hands until we make the necessary, or rather take the necessary steps going forward in the hierarchical structure of our judiciary. The court was kind enough to accept our application and has agreed that it will stay its hands. But it is not a good decision in my humble view. I think that our jurisprudence is regressing. It's unfortunate that the particular composition of the court continues to rule in a particular manner that is not healthy for our society, but that is what we have to deal with, and the government intends to pursue all recourses that are available to ensure that the rule of law is upheld and justice prevails in the end.
AG, I want to thank you very much for joining me today on this discussion. Of course, we've been discussing the ruling by the Court of Appeal with regards to its jurisdiction. To hear the petition number 99, which was dismissed by the Supreme Court on the grounds of non-service, if that's the right term, AG. So again, thanks for joining me.
You're welcome.